I'd like to bring this meeting to order. This is the Standing Committee on Public Safety and National Security, meeting number 14, and we are today discussing Passenger Protect Program and the U.S. no-fly list. And we have three groups represented today, the Royal Canadian Mounted Police, the Department of Transport, and the Department of Public Safety and Emergency Preparedness. We would like to welcome our witnesses this afternoon. We look forward to your testimony. When you begin, introduce yourself. Tell us a little bit about yourself. We won't count it as part of your 10 minutes. And this is only a 1-hour meeting. I can't stay for the entire time, but that's not a problem. Somebody will fill in here. Have you decided who would go first, or should I just follow the order? Mr. McDonald will go first.
Me, Mr. Chairman.
Okay.
I will be making the only opening statement for the group, if that's okay, Mr. Chairman.
For the entire group?
That's correct.
Okay, thank you very much. You may go ahead whenever you're ready.
Okay, thank you very much.
Please introduce everybody right away.
Yes, I will. I'll introduce who is here with me today. On my far right is Christina Namiznewski, the Associate Deputy Minister for Strategic Policy in the Department of Public Safety and Emergency Preparedness. On my immediate right is Lorene Kinney, Director General Aviation Security with Transport Canada. And on my left is Chief Superintendent Larry Tremblay, Director General National Security Operations, obviously with the RCMP. I want to thank you for providing us the opportunity to speak to you today about the Passenger Protect program. Since the December 25, 2009 incident that confirmed the continuing terrorist interest in targeting passenger flights, Canada, like our international partners, has been reviewing its aviation security programs. The prevailing approach to aviation security, used in Canada, United States, Australia, and other countries, involves the use of multiple layers, creating a robust system of defense against threats. As international partners strengthen existing security measures or develop new technologies and passenger assessment systems, it's important for Canada to keep pace with its international partners so we are not the weak link in and the global system remains strong. In this environment, we've continued to work to improve the Passenger Protect program and learn from our experience operating the program over the last 3 years. The Passenger Protect program was established in June 2007 as a mechanism for preventing persons who pose an immediate threat to aviation security from boarding a flight. The program was designed after extensive consultation with stakeholders, including valuable input from the Office of the Privacy Commissioner. The program complements other layers of our system, including the physical screening of passengers and their bags, and the Passenger Protect program is targeted specifically on our core mandate as its scope is focused on aviation security. Le programme de protection des passagers et le
The Passenger Protect program and the supporting identity screening regulations involve a partnership between government agencies and air carriers. To briefly describe the program, Transport Canada, using information from the RCMP and CSIS, provides recommendations to the Minister of Transport, Infrastructure and Communities concerning individuals who may pose an immediate threat to a flight should they be permitted to board. The list of these individuals who pose a threat, called the Specified Persons List, contains the name, date of birth and gender of each specified person and is provided to air carriers. Under the identity screening regulations, air carriers are required to check passengers against the Specified Persons List prior to issuing the boarding pass. When a passenger's name, date of birth and gender match with an entry on the Specified Persons List, the airline contacts the Transport Canada Operations Centre, which is open 24 hours, 7 days a week. An officer on duty will validate the match, make a decision on whether an emergency direction is required to prohibit the person from boarding the aircraft, or take any action required to ensure that aviation security is maintained. concerns about false positives or mistaken identity and long delays were raised to the department before we implemented the program. These have not become issues. The procedures built into the program enable efficient resolution of airline calls about potential matches, leading to minimal delays. The department verifies reports of delays to determine whether they are program-related. We have only one instance where delays were due to the program, and we have worked with the individual to facilitate future travel.
Denied boarding is available through the Transport Canada Office of Reconsideration. This office engages independent advisors to review the case and makes a recommendation to the minister on whether the original listing decision should be reconsidered. Individuals may also lodge complaints with other bodies, such as the Security Intelligence Review Committee and the Commission for Public Complaints against the RCMP. They may also apply to the Federal Court for judicial review. With any new program, questions and challenges are not unexpected. These challenges, such as the case under judicial review, may be useful in determining ways of strengthening the program. Nous avons pris un bon nombre de mesures pour améliorer.
We've taken a number of steps to improve the program since its inception. For example, we amended the identity screening regulations in September 2008, following consultation with stakeholders. We removed the need for passengers who appeared to be under 18 years of age to present identification. This amendment was based on a careful assessment of the regulations, taking into account the low-risk persons younger than 18 represent, the difficulty in obtaining the required type of identification, and the potential for limiting mobility for domestic flights within Canada when proper identification is not available. Requirements were also changed regarding identification documents used at the boarding gate, facilitating boarding procedures. We strengthened the program by incorporating into regulations elements that were previously included in a memorandum of understanding entered into with each air carrier in the program. These include regulatory obligations on air carriers related to the appropriate use, access, and disclosure of information provided to them by Transport Canada in relation to the program. We also dealt with potential issues of non-compliance through amendments that allow Transport Canada's inspectors to issue monetary penalties to carriers for certain infractions against the identity screening regulations.
The program remains an important element of Canada's aviation security program and a key factor in maintaining our credibility in the area of passenger assessment. We will continue to look for ways to improve the security program, ensure the safety and security of passengers, and maintain the efficiency and competitiveness of Canada's aviation industry. We would be pleased to answer any questions you may have. Thank you very much, Mr. Chairman.
Thank you very much. Appreciate that. The usual practice at this committee, as you're probably aware of, is to go around with the various political parties asking questions and making comments for about 7 minutes each on the first round. Mr. Kenya, are you going to begin? Go ahead, sir.
Thank you, Mr. Chair. Thank you for being here today. I support security, obviously. I'm looking for a system that is logical, that is fair to travelers, both travelers who are being screened and persons who, frankly, would never be screened or potentially on the list, so that they can go through expeditiously. The first thing I want to ask is this specified persons list. How is it determined when somebody gets on this particular list? Because, for example, I have constituents of mine who have got on this list, who have difficulty flying, who have been stopped, and one of them was an 8-year-old boy. So first of all, how do people get on this list? And the main point of this particular question is, once they get on, if they shouldn't be on, what can they do to get off?
Okay. I guess just by way of my first point, your problem with the 8-year-old boy, I would point out that there is no one on the list under the age of 18 years, as required by our identity screening regulations.
Let me stop you there. Okay. I had these persons who were in Germany, and the airline stopped them, screened them, and told them that that they were on the Canadian list and they were being stopped from coming back from Canada. So I would like to know how that could possibly occur, and once again, how situations like that can be fixed, because obviously that's an error, and there must be some way. I've not been able to get the Minister of Public Safety to respond yet.
Okay.
I've not been able to in any way find a way to get them off the list. So I'm asking you, what do I do? Why do they have to come to a Member of Parliament to seek assistance? What can they do to get themselves off?
I don't know the specifics of that particular case, but I can tell you that if they were on the Canadian specified persons list, they would have been notified directly that they were on that list. And I am not aware that such a notification has taken place.
So somebody asked this potential. Let's say that the Canadians had decided to bar them because they were perhaps on the U.S. list. Do the Canadians just follow what the Americans say? Is that one possibility?
No, it's not a possibility. The Canadian list is a list, a sole list in and of itself, and has nothing to do with the American list. So
does Canada follow the U.S. list?
We do not.
Okay, fine. So how are these constituents of mine supposed to fix this problem?
Well, the only redress we would have at Transport Canada would be with whether they were on the specified persons list. If they were denied boarding because of being on the Canadian specified persons list, they would have received notification that they were on the list. If they did receive that notification, then they would be able to apply through our Office of Reconsideration for reconsideration of that determination.
Okay, so let's discuss this. This particular program, it's indicated that it's a secret program, and when the name of somebody is actually added to the list, they're not told. Is that accurate?
That is correct.
Okay. Why are they not told? Why is there not a method that somebody can, in essence, defend themselves if they're added to this list?
Well, part of the reason for having the list is people who may indeed be a threat to aviation. We do not want them to know whether they are on the list or not, so that we can keep them on their toes, as it were, with respect to whether they would use the aviation system or not. If someone attempts to board a flight who is on the list, and we make an emergency direction with respect to their boarding, they will be notified that an emergency direction has been made and that they are on the list, and they will be given a summary of the reasons for why they are on that particular list. Okay, and then they can apply to our Office of Reconsideration to get themselves taken off the list.
So, once again, for innocent persons who are on this list, who are barred from flying, would it not be better to let people know that they're on the list so that they can actually do something about it? How is it fair to innocent persons that they're not told?
Well, first of all, there has been no one stopped from flying who is not on the list.
That's never happened.
That has never happened.
Okay. So when you say stopped from flying, what do you mean by that? Because I had constituents that were stopped from flying.
You may indeed have had constituents who are stopped from flying. It would not have been because they were on the specified persons list.
Okay. In circumstances, there's an indication here that the border individual at the scene has the power to decide whether they're allowed to board a plane or not, correct?
No, that is not correct.
Then how does it work?
How it works is there is a list that is provided to the airlines of people who are on the specified persons list. Before every flight, the airlines will reconcile the people who are on their flight against the specified persons list. If there is a possible match, they will phone the Transport Canada Operations Centre, which is a 24/7 operations centre, to obtain further information about whether or not that the person that they feel is a possible match is actually a person on the list. In most cases, the time taken to resolve those questions is usually about 3 to 5 minutes, so it has never resulted in a case of delayed boarding.
There are admittedly false positives.
We have 2 instances where we have, out of 600 calls we've received over the past 3 years, where we have had false positives. In those 2 instances, neither of those people were denied boarding their flight.
Okay, what about my constituents that were denied boarding their flight?
Again, I don't know the circumstances with respect to your constituents, but if they were denied, I repeat, if they were denied because they were on the specified persons list, they would have been notified at the time that they were denied the boarding pass.
There's also, there are 2 things here. I'm running out of time, so I'll sort of do 3 at once. I noticed that there's a reverse onus provision for somebody to prove their innocence. Secondly, if they're not happy with the decision that's then reached, they can apply for judicial review in the federal court.
That's correct, yes.
So in essence, what's occurring here is you're making people prove their innocence. If they're not happy and they can't prove their innocence based on your standards, they have to hire a lawyer, go to federal court and spend that money. And I question, wouldn't it be better to have some independent, such as an ombudsperson or somebody that would look at this and make the decision arm's length away, rather than forcing them to spend money and go to federal court?
Okay, I guess a few points I would like to make, Mr. Chair. One is that we are not saying that anyone who is on the list is guilty. What we are saying is that they are a threat to aviation safety. My second point is, yes, judicial review is one recourse of action that a person may have if they find that they are on the list, but they also do have access to our Office of Reconsideration, which does make available to them an independent reviewer who will review their case and make a recommendation to the Minister of Transport about whether or not their particular case should be reviewed. There are also other avenues open to them, as I mentioned earlier. The Public Complaints Commissioner for the RCMP and the CSIS body for review of their information.
Thank you very much. Ms. Morani, please.
Thank you, Chairman. I'd like to thank all of our witnesses for coming. There's something I'd like to check with you, Mr. MacDonald. You say that the process, when a person shows up at the airport with the air carrier, the person looks at the name, they establish whether there's a match between the name of the person and this specific list, and there is a request then to find out whether this person is the person mentioned on the list, and the person from the Department of Transport carries out this verification and gives authorization. The minister or the deputy minister, whoever it happens to be, gives authorization then for the person to board the plane or not. Is that the way it works?
Vous avez dit aussi
You also said that you do not make use of the American list, but use the Canadian list. Is that correct as well?
Donc, je voudrais savoir.
So what I would like to know is, if you're not using the American list, why are domestic flights in Canada diverted? Because they may be flying over the U.S. And why, according to what I've been told, are there people who are on the American list, apparently, and who are refused boarding? Air Canada also makes use of the American list. Air Canada, I presume it must refer to your list. So I presume that you must automatically refer to the American list.
not make use of the American list. The only instance where a flight in Canada may be diverted to Canadian airspace would be if it was an international flight that might come into American airspace. When it is in American airspace, it would be subject to American rules. If there was potentially a person on the U.S. no-fly list that was going through the American airspace, the Americans may request that flight not enter American airspace on its flight from an international destination to Canada.
Mais pourquoi Air Canada?
Why does Air Canada claim that it uses the American list, that this American list is being used? I don't understand.
The American list, when certainly for any people flying to the United States, because anyone flying to the United States would be subject to U.S. airspace rules, and they would be required to use the U.S. no-fly list.
Une autre question.
I have another question for Mr. Tremblay. What explains your decision to advise the Department of Transport to put someone on the list? What are the criteria that are used? Because Mr. McDonald tells us that these persons whose names are on the list constitute a threat for aviation safety, but they are not guilty. I'd like to know how these people are identified. Is it in relation to their religion, for example? Is it whether they happen to have a beard or not? What exactly are the criteria? Because there's a lot of talk about racial profiling, among others. I'd like to start, first of all, that the RCMP does not put anyone on the list. The RCMP is represented on a committee that makes recommendations, and these recommendations are signed by the Minister of Transport. In other words, the RCMP does see information or does bring information to the committee, but it's not the RCMP that makes the recommendation. In cases where there is information on about a possible threat that a person may represent for air safety, the person may represent a threat to air safety because of the actions. It is based on the actions of this individual, and we only take into account the actions that such a person may have taken without taking into account religion or other type of belonging. I have a document here from the International Coalition of Civil Liberty, and many Canadians of Arab Muslim origin apparently are affected by this list, and there are many people in this category in general. And there are also certain facts relating to CSIS. If they do not obtain delations from certain young members of the Muslim community in Canada, for example, these people may not agree to infiltrate for CSIS. Their name may also be put on the list. I have nothing. I cannot say anything about the activities of CSIS, but I can tell you that when it comes to the RCMP, our recommendations are based solely on actions. There's another question. You say that there were not any that there were not any minors on the list. You say that they were not denied boarding. There was simply a screening that takes place to find out whether these there is a match between a name and the person. Mr. Herbert, for example, who is 10 years old from Saskatoon, wishes to board the plane with his mother, his father, and his brother. They have to wait for a long time. Another Mr. Herbert I'm talking about false positive results at 15 years old from Ottawa, also prohibited from boarding the plane. His name is on a list, a no-fly list. When he wanted to register his baggage, take a flight for St. John, there was another problem. It would appear that there are false positives for children, and you say that the age is recorded, so I can't understand why this misunderstanding could occur.
Of those particular cases, but those delays in boarding would not have been a result of being on our specified persons list.
Mais est-ce que les faux positifs...
Can you tell me whether these false positives, once again, when they affect a child? If a child shows up at the Air Canada counter or any other air carrier who has to check whether the name matches, is this done in the case of a child as well?
Indication, if the person is under 18 years of age, immediately we would know they're not on the list, and that would be, if that information was communicated to us, we would communicate back to the air carrier directly that that person couldn't possibly be a match for a person on our list.
Thank you very much. Mr. Davies, please.
Thank you for appearing before us today. In June 2007, there was a joint resolution from Canada's privacy commissioners regarding the no-fly list. I'm sure you're familiar with that. I'm not going to read the whole resolution, but there are some very revealing parts that I wanted to highlight. It states, among other things, quote, the Aeronautics Act does not provide a clear or adequate legislative framework to support the Passenger Protect program. Transport Canada has not provided assurances that the specified persons list will not be shared with foreign governments or their agents. The program involves the collection, use, and disclosure of excessive as well as sensitive personal information of travelers. The program creates real risk of harm to individuals as a result of inaccurate or unreliable information, noting that the U.S. Department of Homeland Security recently acknowledged a significant concern about the quality of data and its underlying intelligence in U.S. lists. The resolution called on the government to refer the PP program to a committee for full debate and scrutiny. It calls on the government to enact legislative processes to govern the use of the no-fly list, and it calls on the use of the no-fly list to be suspended until these actions have been taken. Have any of those recommendations been put in place to your knowledge?
I'm not sure about those specific recommendations, Mr. Chair, but I can point out that the Office of the Privacy Commissioner did do an audit of the program that was conducted in November of 2009, and that audit concluded that the Passenger Protect program does indeed comply with the Privacy Act, the Aeronautics Act, and the applicable regulations and policies.
Okay, now I'm going to quote from a report released by the International Civil Liberties Monitoring Group. They said in 2008, Transport Canada's Office of Reconsideration asked two independent security advisors, Mr. Fensky and Ms. Sutton, to review the complaint of a man whose name was placed on the SPL and barred from flying. In their report, dated October 28, 2008, they indicated that the PPP is plagued with serious problems and its legal and regulatory framework needs to be reviewed. Has such a review taken place, and if so, what was the result?
I think we're constantly reviewing our practices and programs to try and improve on it as best we can. We have not undertaken any specific review with respect to the comments of the BC Civil Liberties Union, but we are in the process of doing a complete review of our aviation security regulations, which would comprise a review of the identity screening regulations to which this program applies.
Okay, I want to be a little bit more focused because this was Transport Canada's Office of Reconsideration that asked the two independent security advisors to review the complaint. Is that correct?
Yes, that is correct.
And they gave a report that said it's plagued with serious problems and the framework needs to be reviewed. I'm not talking about ongoing reviews that every organization does. Was a specific review done to comply with that recommendation? That's what I'm trying to find out.
Thank you. Larry?
There was a significant review of our processes, procedures, and our system in place when we received that report, and the issues raised were looked at. It's not something that I can comment on in detail because it is subject to litigation.
Is there a written report that's been produced of that review? No? Okay. I want to turn a bit to the U.S. Secure Flight Program, which I'm more concerned about right now. Of course, recently, Canadian Airlines have been told that they have to send API, name, date of birth, etc., but also passenger name, reservation information, for instance, all information on the reservation system to Homeland Security within 72 hours of boarding a flight in this country. U.S. Homeland Security will then send a directive allowing deciding whether or not a Canadian can board, sending passenger for secondary screening, or banning them entirely from the flight. We were told that Canada had secured an exemption for domestic point-to-point flights within Canada, even if it flew over the United States. But we're finding now, though, that there have been some incidents where people were banned from flying even in those circumstances. There was a well-known case, I think it was Mr. Almalki flying from Windsor to Ottawa last year, I believe it was, who couldn't fly. So we're told that the U.S. secure flights does not exist in that situation, and that we have that exemption. Is that true? Do you know if that's true? Do we have that exemption?
Yes, we do have that exemption.
Do you know why? I'm sure I have his name right. Is it Mr. Almalki who was barred from flying last year? Does anybody know why that is then?
I can't speak to that. That would have been a decision of Air Canada.
Okay. So now it is the case, though, that Canada has to send information on flights to Homeland Security for flights that don't touch the U.S. If you're Canadians flying from Canada to Mexico or Canada to South America, and not even touching the States, but flying over their airspace, it's true that Canadian Airlines have to send information to Homeland Security. Is that right?
No.
Perhaps I can answer or attempt to answer the question. The U.S. Secure Flight Program is a program that will apply to flights that fly within domestic United States, continental United States, as well as flights flying to the United States and flights that are flying over the United States. At this point in time, they have yet to implement the overflight provisions, so that the flights that would leave Canada flying to Mexico at this point in time are not covered by the Secure Flight Program, but that is imminent.
It's imminent. So can you confirm if Air Canada is complying with Secure Flight?
Any flights that Air Canada has that would fly within the domestic United States, my understanding is that the domestic implementation of that program has happened, and that they are in the process of moving towards the implementation of flights flying from Canada into the United States. There are two programs in the United States. One of them is called APIS, and one of them is called Secure Flight. The APIS program is a program that's used by Customs and Border Protection, and it's very similar to a program that Canada has, where advanced passenger information, passenger name record, is sent to the U.S. government, and it's sent for the purposes of customs and immigration admissibility, as people land in the United States and have to go through customs.
I won't interrupt, I don't have much time. I'm sorry. I'm not concerned about, what I'm concerned about is Canadians that don't go into the United States. A Canadian who has no intention of going there, who wants to fly to Mexico City, could be barred, not because of anything happening in this country, but because an entity in the United States says that they can't board that flight. Do you have any position on that, or are you aware if the Canadian government has expressed any reservations or in defense of Canadians in this country in that position?
There's been a number of things that the Canadian government has done. There was when the U.S. Secure Flight program was being contemplated, the U.S. government issued something called a Notice of Proposed Rulemaking, which is the process that they use as they're moving towards the implementation of a program. In response to that Notice of Proposed Rulemaking, there were a number of overtures that the Canadian government made to the U.S. government, and at that time we sought a full and complete exemption from the entire application of the program. There were a number of other interventions that were made by other countries, as well as other groups, a number of which were within the United States. As a result of Canada's intervention, the U.S. government made a determination that they were willing to give us the domestic exemption, so as you've mentioned, flights between 2 points within Canada. But at this point, they've been clear that they're not contemplating an exemption for the overflight provisions.
Has Canada responded to that decision?
That'll have to be your final question.
Oh, I'm sorry. Has Canada responded to that?
We have had a number of conversations with the U.S. government up to and including at the ministerial level, expressing our desire to be completely exempted, which did not happen at the end of the day, and the U.S. government's decision is reflected in their final rule, which was issued in October of 2008. So we are not exempted from the application of the overflight.
Thank you very much. Mr. McKenzie, please.
Thank you, Chair, and thank you to the panel for being here today. I think one of the problems that we deal with this whole area is there are a number of different, if I just call them no-fly lists, that get mixed in, and so sometimes when a Canadian carrier in a foreign country turns somebody away, it's not necessarily because of the Canadian list that may exist. And certainly, I think most of us are aware that the UN there's a UN no-fly list. The Americans have theirs. We have them. Other countries have their own, and I think sometimes it all gets mixed in, and if it's a Canadian that gets denied flight, it always seems to come back that it must be a Canadian reason for it. But Mr. Davies, I think, has brought up something that, as Canadians, we need to know and respect, and that is that the airspace above Canada, Canada being a sovereign country, is our airspace. We rule the skies above Canada, as does every other country. So the Americans may have their rules about flying through their airspace that has nothing to do with landing in the United States. And I think, just correct me if I'm wrong here, but the airlines get the list, and it's up to them to follow through with the names that are on the list. Now, you indicated, I think, Mr. McDonald, that we had 2 false positives in 3 years?
That's correct, yes.
2 false positives in 3 years would not seem to me to be an exorbitant number, but what we do hear about are a lot of others that probably more relate to the Americans that may not have the descriptors and the identifiers on our list. And I do believe, you said it and I read it, that we do not have people on there under 18.
That's correct.
So if someone was on there that was 19 and a 13-year-old showed up with the same name, how long should it take or would it take to identify that somebody has mixed or got the name together, but it's not the same person because the identifiers don't match?
A case like that would seem to me to be dead simple, and it would take a matter of mere seconds to make that determination. Our experience with the 600 or so calls we've received is we can resolve any questions or issues on an average between 3 to 5 minutes.
And that's available to the airlines 24 hours a day?
24/7.
Okay. And my friend Mr. Kanya, related an incident, and I know that it would be of great concern to a family who has an 18 or an 8-year-old that couldn't get on the flight. But would Transport Canada maintain our Passenger Protect? The Minister of Public Safety does not maintain that record, correct?
It is Transport Canada that maintains the list,
So,
that's correct. The Minister of Transport.
I would suggest that Mr. Kanya might write to the Minister of Transport to try and clarify the particular issue that exists.
Certainly, we would have no problem with that, but I would again note that if that person was denied boarding because of being on the specified persons list, it is our policy to ensure that they are aware that they are on the list if they were denied boarding, and they would be given reasons as to why they're on that list. So if that was indeed the reason why this particular person was not boarded, they would have that information with them.
Could that person be on some other country's no-fly list and the identifiers have picked him up even though he was going to be flying to Canada on an Air Canada flight?
I mean, anything is possible. The airlines maintain all types of different lists for flyers who behave badly on flights, for people who don't pay their bills, for any number of things, as well as other countries' no-fly lists. So, I can only speculate.
And I think that's the other one of the important things is that although we may have, countries have those no-fly lists, the airlines may have their own list for a variety of reasons, including some of the things that you mentioned there from an economic perspective that someone can't get on.
That's quite possible, yes.
Okay. The other thing is I went through the Privacy Commissioner's report, and I did note that the one that I saw, more recent one, that the examination occurred June of 2007 to March of 2009. Would that be the most recent of the Privacy Commissioner's reports?
Yes, that's the only one.
Okay.
Yes.
What I did notice then when I went through it was I noticed that there were some other agencies that had concerns dealing with a previous report. And I'm wondering if, I'm not sure where the other report came in because the program is fairly new.
Yes, the program's only 3 years old.
Okay, would this have been the only Privacy Commissioner's report conducted on the program?
Yes, there was only the one privacy audit conducted on the program.
Okay, so in this report ending March of 2009, can you tell me, in a broad sense, has the department identified within the department and corrected these issues that have been highlighted that may be concerns?
Yes, we have. Essentially, I guess I'd point out, first of all, that the report itself indicated that adequate collection controls to protect personal information were in place, that acceptable controls for the use of personal information was in place, that controls for the retention and of personal information were there, and mechanisms were there to ensure that the specified persons list was accurate. That being said, there were 4 recommendations that the Privacy Commissioner made with respect to how to improve the program. One, they indicated that when the Deputy Minister receives a recommendation from the advisory group, the Deputy Minister is delegated by the Minister to make the determination on whether someone is put on or taken off the list. When she receives that information, she should receive with it the full file. When the program first started, the Deputy Minister was getting a summary of that file with all information being available to him at the time if he should wish to avail himself of it. We've now changed that practice. When a recommendation goes up to the Deputy Minister, she receives the full file and can review the full file before that determination is being made. The second item was with respect to the computer system that's used to maintain the list. The Privacy Commissioner felt that we should have a formal accreditation and certification with respect to the technology security. We felt that we had done that. There was a bit of an issue there that we went back and forth on. To satisfy the Privacy Commissioner, we undertook to do an accreditation and certification of the security of the system, and that has now been done. The Commissioner thought we should be amending our identity screening regulations to require air carriers to report any privacy breaches, i.e. if the list got into someone's hands who wasn't screened to see it. We actually have a provision in the regulations which makes sharing or distributing of the list against the law. But the Privacy Commissioner thought we should also put the onus on the airline should that information be shared to have the airlines actually notify us of that. That is something we're considering as part of the regulatory review that I talked about. And I guess just the final item was that they thought we should enhance our oversight activities of the airlines and how they treat the list, and we have accepted that recommendation and we have increased our oversight of the airlines.
We'll have to come back to you.
Okay. Thank you. Thank you.
Okay, Mr. Rezhnevsky, please.
Thank you, Chair. These lists, they're name-based. Do you also provide photographs of individuals that are on the list or passport information?
No.
So it's strictly name-based?
The only thing that would be on the list would be name, date of birth, and gender.
And if there's been a clear record established that results in people being on this list, one would assume that photographs of these individuals would be available. Why wouldn't those be made available on the list for verification at ticket counters if a name pops up?
Because we want to keep that portion of the information within the federal government. We feel it's much easier to keep that information secure if we hold on to it. That is why we make ourselves...
So if you've provided details of the name, age, etc. of an individual, and the individual is standing right there,
yeah.
Why wouldn't you provide a photograph to the ticketing agent or the boarding agent so that they could in fact verify this is the individual that's on the list? I don't quite catch that particular logic. But let me move on. You said there have been 2 false positives that you're aware of. Those are people that were prevented from boarding.
No, that's not. Could I just? It was a false positive. The call came to our office. We managed to resolve those issues, and those people did board their flight.
Okay, but those are people that were on the list. How often have you had to remove people from a list who've challenged them being categorized as being a threat and having to be on the no-fly list? Has that occurred?
No.
So nobody has challenged, to date, nobody has challenged the fact that they're on a no-fly list in Canada?
Yes, there is one case before the courts right now where a person has challenged being on the list.
Okay. So, but there is a case, so there is a precedent for it, but you don't inform people if they're put onto the list. You said that previously. People are not informed when they're put onto the list?
That is correct. They're only informed if they try to board a flight.
And there's a committee that establishes this. Mr. Tremblay, are you part of that committee, or?
No, sir. Member from within my office, sir.
Okay. And I wasn't clear. And it's basically a sit-down with the minister. Is that correct?
No, sir. A member of the RCMP, a member of the service, and a member of Transport Canada do make, in fact, that SPLAG committee. Based on the deliberation within that committee, a recommendation is made.
To?
Transport Canada, who takes that recommendation to...
And who within Transport Canada is the final decision maker?
That responsibility has been delegated to our Deputy Minister.
So the Deputy Minister makes this decision. Now, it's interesting because we value our fundamental freedom of movement. We're placing a restriction on people's ability to have that freedom of movement. Basically, we have a bureaucratic system that acts as judge and jury with no ability of individuals to respond. Now, here's where the problem. I heard your comment that, well, we want to surprise them, catch them at the counter, but there's no criminal charge in this. But let's take a look at these potential circumstances. You said this information is shared with third countries, many third countries.
Excuse me, no, I did not say that. We do not share the list with any other countries.
So it is not shared?
It is not shared with any other countries.
So it's strictly shared with airlines that would have their ticket counters in these countries. So let's say somebody was boarding a plane from Syria to Canada, coming to Montreal, and they're prevented from boarding, and they raise a fuss. The ticket agent has to call authorities. What would they tell the authorities there why the person's been prevented from boarding the plane?
It's a hypothetical situation, so I wouldn't know what the ticket agent would tell the person if they were denied boarding.
See, what I'm getting at is the fundamental principle. Okay, just the fundamental principle that you're basically judged guilty, and a freedom is impinged upon with no opportunity to either clarify or agree that perhaps there is good reason.
We'll have to continue that discussion later. Mr. Rathgaber, I've got indication you're sharing your time with Ms. Glover. Is that right?
That's correct. I have one question only. How do you handle the situation of individuals with multiple names? Certainly my name is fairly unique, and Mr. Resnesky's name is pretty unique, but I happen to know 3 individuals named Don or Donald Davies. What criteria are used for people with common names and people who share names?
Well, if there's a again, we use the three pieces of data that are first given to us. One is the name, one is the date of birth, and the other is the gender. So while there may be many common names, people with the same date of birth is far less common. Although I would certainly note that it's not impossible. If you got the name and the gender and the date of birth all match, the call would then be placed to ourselves. We have more information on these individuals on file, and then we can converse with the airline to determine whether or not that person who is standing in front of them is indeed the person who is on the list.
What type of identification do you require for date of birth?
A government-issued piece of identification.
Okay. Thank you. My friend Ms. Glover has some questions.
Thank you, Mr. Chair. I want to welcome you all here as well. C'est un plaisir de vous recevoir dans notre comité. I personally am very glad that we take security on our aircraft seriously, particularly when we look at incidents like Christmas Day. It is becoming more and more apparent how the threat of terrorism can affect all of us, and we have unfortunately lost some Canadians in terrorist attacks. And so I am glad that we do have some measures in place to protect our security. But we've dealt a lot with hypotheticals today. I would like to ask some direct questions, but I'm not sure whether or not you're permitted to answer them. So please feel free to tell me if you are not permitted to answer them. How many people, in fact, are on our Canadian Passenger Protect specified persons list?
That is something I can't answer.
Okay, thank you. The other questions I have are specific to some questions already asked. Mr. Wisniewski asked a question about photographs. Do you have photographs of each and every one of the people that are on the specified persons list?
We do have photographs of some, but not necessarily all people who are on the list.
Very good. And I used to work in law enforcement, and we too do not have pictures of every single person we deal with. And so I would say that it's impossible, given that you don't have pictures of everyone. It would be impossible to look at a picture and use that in every case as another identifier. So I just wanted to help to make sure we cleared that up. There is one case that you suggested is before the courts at this time.
Yep.
And I am wondering, is that person, while this is being debated in court, is that person still restricted and on the specified persons list?
I can't comment on whether people are on or off the list.
Okay. Okay. Well, that poses, if it was not that person, less specifically, if a person used their discretion to take their case after having been reviewed the first time by the review panel, if they decided to take it before the courts, would they be removed from the specified persons list while they were pursuing an avenue in court?
The only way to be removed by the list is for the minister to remove them from the list.
Okay. Okay, I think I'm having a hard time understanding whether or not, I'm concerned about, obviously, in the interim, whether or not we are ensuring that people who are a threat are not permitted to travel, even if they are seeking retribution in a court. But it sounds like perhaps that's a question you can't answer directly. I am also concerned that there's some miscommunication about the American list process and our list process. I believe there may have been a situation that Mr. Kanya is trying to deal with his constituent that may not, in fact, have been a Canadian-based problem. And I do hope that his constituents, through his assistance, find an answer to that. And I think there have been some suggestions. But it seems clear to me that our list does not contain the names of children.
It does not.
And so I am confident that that 8-year-old was not prevented from boarding a Canadian vessel because of our list, and I just want to make that clear. I'm convinced, given what you've said, that that is in fact the case. I want to know also, Air Canada, for example.
Mrs. Glover, you're over 5 minutes, so if you could just wrap your question and then we'll let the witness answer.
Who from the airlines have access to this list? How do you keep that as narrow as possible. Who from the airlines has access to this list?
They have people designated within their organization with the appropriate security clearances to handle the list.
So they have security clearance. They are
Yes.
special,
That's
so
right.
to speak. Thank you.
Monsieur Denoyer.
Welcome. My question is for Mr. Tremblay. My first question, you talked about the existence of a committee that studies the names of persons who will be put in the list. Yes, recommendations, yes. Can you tell me how many people are members of this committee? There are 3 members. 1 from the RCP, 1 from CSIS, and 1 from Transport Canada. Can you tell me what the criteria are that the committee uses to make its recommendations to have a person's name put on the list? I imagine that if this person is a member of a terrorist organization, then the name will be put on. Yes, I can be more specific, and once again, I will base my answer on the determining factor being the actions that have been taken by this person or participation in an organization, person that has a history of being involved in activities that represent a threat to air safety, someone who has shown an intention to take action against air security, or someone who has been involved in an activity that supports threats. So when it comes to profiling, when you choose these persons or name these persons, these may be terrorists, people who have committed a crime or an offense of some sort. A person who has committed a crime that does represent a threat to air safety. Not any type of crime. There has to be some type of link between the crime and air safety. Those are the only 3 criteria, are they? Yes, the generic criteria. Someone who has been demonstrated as representing a risk to air safety. Can you give us an example? I'm sure that you can think of a number of instances, because these lists have lots of names. I am not sure that I can give you this kind of detail, a specific detail. Someone who represents a threat, someone who has already made a verbal threat to an air company or about a certain flight will certainly be considered in this category. Someone who has taken action in the past and who demonstrates that he or she still has the ability and the intention to be a threat. Those are the only criteria, are they, or are there any others? Yes, those are the criteria that have been defined. So I take it that there could not be someone who doesn't have any criminal record. The problem may be how is a terrorist definition, how is it defined by you in the RCMP? By definition, it is a group that makes use of violent activities in order to achieve its objectives, in order to achieve its ends. Can you give us an example? For political or religious reasons, for example, a person may decide to place a bomb. You're thinking then that there might be religious organizations that could be targeted. There might also be, no, not organizations, individuals. In or religious organizations? No, I'm talking about individuals who have, through their actions, have demonstrated that they represent a threat. You talked about organizations. Yes, but I want to specify that I'm not talking about an organization. Someone who is acting within a religious organization might be targeted. Religious or any type of organization. Any type. It could be a union, I presume. Yes. Are there any unions that could be targeted? No, a union would not be targeted. It's an individual. The person who is within this group. religious belonging or a professional association, a political association is not a factor. It's the activities of the person that count without any consideration being given to religion, nationality, or political affiliation. What type of activity then would it be, or what is the affiliation? I said without affiliation. I'm saying that it's the activities that were carried out by this person, activities committed by this person. Let us take the example of a person who's within a religion.
We'll let the witness finish.
What type of activity would we be talking about? Sometimes we think that this is arbitrary. I know that people whose names are on this and who have no criminal record, at least to the best of my knowledge, they were profiled and they stayed 9 months on this list, and then afterwards their name was taken off. In Air Canada, and I was present, and in Air Canada they were told that you are on a list.
Let the witness answer.
Okay. I think it's not the only organizations that would indicate that a person may be considered for being on the list would be a recognized terrorist organization. You know, I don't want to. Al-Qaeda is a perfect example. A person is a known member of Al-Qaeda. They have experience in bomb making, perhaps, and they actually attempted to blow up an airliner 10 years ago. This is all hypothetical, okay? That may be a good candidate for someone to put on a specified persons list.
Okay, I'd like to thank the witnesses very much on behalf of the entire committee for your very helpful testimony, and we will break for 2 minutes to allow our next round of witnesses to take their chairs. If I can ask everybody to please resume their seats. It's an unruly bunch here, Rick. No, he made me pay him $20. Okay, we'll get the proceedings back underway. I'd like to welcome all of the witnesses to the Standing Committee on Public Safety and National Security. I understand that each of you have been told of our procedures, but to go over it, each one of you will have a presentation that you can make originally to the committee, up to 10 minutes, and then we will proceed with questions. I understand that we're going to begin with Madame Bernier on behalf of the Privacy Commissioner Office.
Thank you very much. I am accompanied by Carmen Bagley, who is a senior policy analyst with our office. We're very pleased to be here today, and we are happy to discuss the implications of certain Canadian aviation security measures in relation to privacy. In fact, we commend you for addressing this issue. We would argue that the challenge of integrating privacy and security comes to a head most acutely in the context of aviation security. Aviation security measures affect us all, and they put our personal information in the hands of the most powerful authorities in the land. The risk for misuse that comes with any collection of personal information is all the more consequential in that context. The one message I would like to leave with you today is this: effectiveness of security and protection of privacy are not at odds. In fact, they both reside in a streamlining of collection of personal information to what is strictly relevant and necessary. To apply this approach, we must look at Canadian values as enshrined in the Canadian Charter of Rights and Freedoms and in the Privacy Act. On the basis of these documents, as well as on the basis of the case law that interprets them, some criteria emerge on how to define how far the government can go in limiting privacy in the interest of security. These criteria may be summarized in 4 main points. The right to privacy is a fundamental right that cannot be infringed unless it is demonstrably necessary in the interest of the public good. Secondly, it follows from that the collection of personal information can only occur when it is proven necessary, and it must be proportionate to that necessity. Thirdly, that necessity must be assessed on an ongoing basis by verifying that the collection of personal information is indeed effective and necessary in relation to the identified necessity. And fourthly and finally, it must be demonstrated that there are no less privacy invasive alternatives to meet that necessity. This lens ensures that we both respect the right to privacy in analyzing security measures and that we duly take into account the security needs that must be met. J'appliquerai donc cette lentille.
I will apply this lens to 2 aviation security measures currently in use. Firstly, the Advanced Passenger Information Program and Passenger Name Record, and secondly, the Passenger Protect Program. First of all, I'll deal with the Advanced Passenger Information Program and Passenger Name Record. Airlines are required to provide the Canada Border Services Agency with passengers' personal information in advance of their arrival in Canada, as well as the passenger name record, which shows the passenger's travel itinerary. In both cases, this information is retained in the Passenger Information System, or PAXIS, for a minimum of 3.5 years. Our office expressed concerns about the program from the beginning, and in response, the following privacy controls were incorporated into the program. The retention period for the personal information was reduced to what was deemed strictly necessary. We obtained that a progressive depersonalization process is implemented so that after 72 hours, the information on a passenger's identity is separated from his or her travel information. And lastly, the use of the personal information is limited strictly to the fight against crime and protection of national security. Although we are satisfied with these charges, the necessity of collecting such personal information and the safeguards required to protect the information still need to be reviewed.
Program. As you know and you have just discussed, we have taken an interest in this program, and in fact, we have audited it most recently. And we have found a few areas where we felt improvements could be made, although we have also found that Transport Canada generally uses adequate measures to protect the personal information within its control. As you have heard, all of our recommendations have been accepted, and they are all either implemented or being implemented. Finally, I know that you are also interested in secure flight. On this matter, at this point, I will only say that it is a U.S. government program, therefore outside our jurisdiction. However, we will work with Transport Canada and Public Safety Canada to review any measure the Canadian government will implement in response to secure flight. En conclusion, j'aimerais insister sur la nécessité.
I would also like to emphasize the need to respect privacy in security measures to the benefit of both security and privacy by limiting collection of personal information to what is strictly necessary and justified in a free and democratic society. Thank you, and I'd be happy to take your questions.
Mr. Chairman, committee members, thank you very much for having us. My name is Michael Vaughan, and I'm the Policy Director and a lawyer with the BC Civil Liberties Association. These prepared remarks are meant to complement those of the International Civil Liberties Monitoring Group. I'm going to be discussing the Passenger Protect program, and my colleague, Mr. Tassé, is going to be discussing secure flight. I'm looking forward to perhaps endeavoring to sort out some of the Byzantine elements of which list constitutes what kind of restriction. So let me just give you a brief overview of where we are with the Canadian no-fly list. Passenger Protect, as you've heard, coming into force in June of 2007. The regulatory impact analysis statement of the identity screening regulations of that piece of legislation explicitly cites the push from foreign governments in developing this program, specifically noting that this program was supposed to be a significant step towards achieving the goal of developing a comparable approach to passenger assessment, which the Security and Prosperity Partnership had identified as a significant goal. Passenger Protect was meant not only to dissuade the U.S. from its repeated threats, starting in 2005, of imposing the U.S. no-fly list on all Canadian air flights crossing into U.S. airspace. It was also meant to curtail the domestic use of the U.S. no-fly list by airlines in Canada. The BC Civil Liberties Association wrote to Transport Canada in 2006 regarding this use of Canadian airlines, most notably Air Canada's U.S. no-fly list vetting for domestic flights within Canada. And the response came back thusly. This is the quote. Transport Canada has no regulatory or legislative authority in place to prevent Air Canada from taking this action. However, we are of the understanding that once the Canadian program is in place, Canadian air carriers will be in a position to end this practice. Not only do we submit that it is relatively unthinkable that Transport Canada has no authority to prevent passengers on domestic Canadian air flights being subjected to a watch list of a foreign government compiled on the basis of secret information, but further, the practice of vetting domestic passengers against the U.S. list has indeed not stopped with the introduction of our own program. We have, as it were, the worst of both worlds. While the Passenger Protect program is by no means as notorious as the U.S. counterpart, it is nevertheless deeply flawed and very likely unconstitutional in our submission. The program is ostensibly built on the 2004 amendments to the Aeronautics Act that were introduced via the Public Safety Act 2002. The key provisions are entitled emergency directions, and those provide authority to the minister or the minister's delegate to make an emergency direction where the minister is of the opinion that there is an immediate threat to airline security or safety. An emergency direction lasts for 72 hours. Of course, the program we are discussing right now is called a no-fly list. If you are wondering how a person is vetted months or years in advance as being, as per the legislation, an immediate threat to aviation security, it was explained to me thusly. A person is considered a generic threat, and then they become an immediate threat the minute they try to get on a plane. If you find that definition strained, or rather bizarre semantically, I suggest that it is the kind of rhetorical round peg trying to be smashed into a square hole that is the signature of Passenger Protect. It seems infinitely more likely that one of the reasons we cannot notify people about their inclusion on the specified person list is because it does not accord at all with the notion of the 72-hour provisions in the Aeronautics Act that provide for immediate threat. The Public Safety Act was certainly debated, but there has never been any parliamentary debate on the creation of a Canadian no-fly list. Regulations were passed and guidelines were drafted so that the program that is supposedly authorized on the basis of emergency directions looks somewhat like you've heard the outline. Advisory group represented by Transport Canada, CSIS and the RCMP, review names that have been submitted by the RCMP and CSIS for inclusion on the list. This list is nowhere accounted for in the statute. Passengers are required, as we've been told, to show government-issued ID to find out whether they are a match on this list. If a match is made, the airline staff must immediately inform the Minister Office or their delegate who decides whether to issue this emergency direction. That person who has been decided to not board an airplane has the recourse of the Office of Reconsideration, which uses independent external advisors, although I should just note they have no immediate recourse, of course, for getting on the plane. The Office of Reconsideration has external advisors for the review of this application, and they make a recommendation to the Minister. Bare bones outline, you've heard that. Since its inception, there have been serious and persistent concerns about the legality and practices of this program. To begin with, the legislative scheme itself does not add up to the program. There is no provision for a list, as I've highlighted. There is such a profound disconnect between the enabling legislation, the regulations, and the actual program that it purports to authorize, that numerous legal opinions maintain that the program may not even be found to be prescribed by law for the purposes of the Charter. Even if this vague and disjunctive legislation scheme were to be found prescribed by law, there are yet other Charter hurdles to pass, including the one that I'm going to suggest is the primary one, which would be Section 7 of the Charter. Concerns about procedural fairness include the Minister's discretion, which is virtually unfettered, The audit by the Privacy Commissioner's Office found that these, and we've heard this before, unsurprisingly were decisions that were not reviews but actual rubber stamps. We've been told that now the Deputy Minister, who is the delegate, has the entire file. It still just strains credulity to believe that this entire file is going to be reviewed while the airline is on hold, who's called up for the quote-unquote decision. The criteria that we've heard discussed is in fact not only non-exhaustive, it is vague and quite frankly legally non-binding. There is no legal status to the quote-unquote guidelines for criteria for the advisory group. Various charter rights are at issue. These have been hinted at. But the central one, as I say, is Section 7, life, liberty, and security of the person, and the right not to be deprived thereof except in accordance with the principles of fundamental justice. Now, the implications of being denied the ability to get on an airplane are always deeply serious, but nowhere more dire than the implications that have been suggested, where a person who has been unaccountably labeled a security threat is stranded in a foreign country and denied the ability to board an airplane to come home to Canada. The Passenger Protect program is in fact being legally challenged right now, as you've heard. The challenge is a very telling snapshot of the problems with this program. The challenger did apply to the Office of Reconsideration, and those independent reviewers agreed with the assessment that this is probably not a legal program. They were concerned about the discretion that was unfettered. They were deeply concerned about the vague, selective, and incomplete evidence that was provided in terms of the application of those decisions. And the independent reviewers actually did recommend to the minister, as per the legislation, that this name be removed. That decision was undertaken to not do that very thing. So summarily dismissed. In conclusion, let me just state my main points in this very, very brief submission. The government has repeatedly failed to produce one shred of evidence to support the proposition that no-fly lists increase aviation safety or security. The current system was effectively implemented through stealth, never debated, never spelled out, nor seemingly even envisioned in the enabling statute. The legislative misfit of this program is so pronounced as to make it doubtful whether it is even prescribed by law for the purposes of the Charter. And even meeting this hurdle, we have serious Charter considerations. So I'd like to just say that it is long since past the time to end the silent, bureaucratic implementation of security programs that so deeply affect the rights of Canadians. This matter is even more pressing than I'm suggesting because of the even more invidious rights violations that are on the horizon due to secure flight.
Thank you, Ms. Vaughan. Monsieur Tassé.
Merci, Monsieur le Président.
Thank you, Chairman. I am Roch Tassé. I'm a National Coordinator of the International Civil Liberties Monitoring Group, and I'd like to thank you for inviting us to appear here to give our testimony.
LMG shares all of the concerns expressed by my colleague here from BCCLA with regards to Passenger Protect, especially that it was introduced by the back door without any adequate legislative basis, without any discussion in Parliament, and very likely in violation of Article 7 of the Charter. However, I would like to focus my presentation today on the new U.S. Secure Flight program. While the Canadian Passenger Protect and the U.S. no-fly list that we've known so far have made life miserable for many airline passengers and unbearable for others, the incremental introduction of the U.S. Secure Flight program over the last few months raises even more dramatic concerns and could literally ground many Canadians and visitors to Canada who have no intention to ever travel to the U.S. The avowed aim of Secure Flight is to shift pre-departure watch list responsibilities from airlines operators to the U.S. Transportation Security Administration and to remove the secret watch list from the hands of airline companies. Under the final rule of the international component of Secure Flight that were published in late October 2008, airlines are required to transmit all passenger information to Homeland Security and U.S. Customs and Border Protection 72 hours before departure for all flights to and from the U.S., as well as for all flights that overfly U.S. territory. This includes not only the basic API information like name, gender, and date of birth, but all information contained in the reservation systems, known as PNR. After running a risk assessment for each passenger using data mining technology, Homeland Security in turn issues a boarding pass result back to the airline. The result instructs the airline to issue a boarding pass, to deny permission to travel, or issue an enhanced screening requirements. These regulations give access to the U.S. to a whole subset of information on air passengers who are not entering the U.S. but merely overflying its airspace. The program gives the government of a foreign country a de facto right to decide who gets to travel to and from Canada, since the vast majority of Canadian flights to and from Europe, and all the flights, of course, to Latin America and the Caribbean, will overfly U.S. territory. According to an internal document from Public Safety that was obtained by the Canadian press last December, the U.S. has provided Canada an exemption only for domestic flights that transit the airspace of continental U.S. between two Canadian airports or locations. Let me quote from that document. The quote is from page 9 of the document. I'm quoting. Canada will be, this is Public Safety Canada saying this, Canada will be subject to the Secure Flight Program by late 2009, although officials at Homeland Security have confirmed that they would consider granting an extension if there were assurances that Canada is pursuing a comparable program. There are a number of concerns that the Secure Flight Program poses for Canada. Secure Flight affects both passengers and airlines. Airlines will be compelled to share personal data with the U.S. government, an act that is currently prohibited by the Personal Information and Electronic Document Act, PIPEDA. It is possible that Canadians overflying the United States could be denied boarding based on U.S. no-fly lists that were developed based on lower U.S. risk tolerance. There are also no guarantees how the U.S. will use the information it obtains from carriers overflying its territory. End of quote. And then the document goes on to recommend that to address these concerns, Canada should develop a more robust program known as Air Passenger Assessment System that would meet the comparability test of secure flight. This raises numerous concerns and questions with regards to the amount of information that will be collected on travelers, the standards and criteria to be applied to put a person on the list, and the number of people who will be added to the list to satisfy U.S. requirements. And also the document makes no references whatsoever to the legislative basis required to implement such a program. The Secure Flight Program became active on January 27, 2009. When it will be fully established, it will encompass more than 70 U.S. airlines and roughly 150 foreign airlines. As of March 31st, 2009, the program has grown to include 74 U.S. airlines and 19 foreign airlines in some way. Of those, Secure Flight assumed watchlist matching for 5 foreign airlines. Air Canada is most likely one of those five airlines already using Secure Flight. In an email sent to the Montreal Gazette last February, a spokesperson from Air Canada admitted for the first time that, and I'm quoting, "For flights to and from the U.S., as well as flights overflying the U.S., we are obligated by law to enforce the U.S. no-fly list." End of quote. So it would seem that Air Canada is already violating PIPEDA, Canada's privacy regime. There are grave consequences for Canada's sovereignty here. It creates a very real possibility that the charter rights of Canadians and their rights to privacy are being violated by the legislation of a foreign country without Canada being able to defend those rights and the rights of Canadians. Several cases have already been reported where Canadians have been denied boarding by the U.S. even for domestic flights in Canada. That includes the case of Abdullah Al-Maki, who, after having his name cleared in Canada by the Yakabuchi inquiry, was denied a boarding on an Air Canada flight between Toronto and Windsor last December. He was told by Air Canada that he was on the U.S. no-fly list. In this case, not only did Air Canada violate PIPEDA, it did not even take into account that there is an exemption in Secure Flight for purely domestic flights that overfly U.S. airspace. There are other concerns related to Canada's sovereignty. For example, half of the cabinet of Evo Morales in Bolivia are persona non grata in the United States. So if Canada were to invite one of those ministers for a diplomatic meeting in Canada, it is ultimately the U.S. who would decide if that minister has the right to come to Canada after being invited by the Canadian government. The same could apply to refugee claimants from Colombia who, even if they were admitted by Canada, could be denied the possibility of leaving their country by the U.S. Disclosure of personal information to the Department of Homeland Security on passengers traveling to certain destinations, particularly Cuba, could lead to very unpleasant consequences. For example, this information could be used to identify Canadian companies who do business with Cuba or penalize travelers who have visited Cuba by subsequently refusing them entry in the U.S. How will Canada ensure that the U.S. not use Secure Flight Program to apply its Helms-Burton Act, which imposes penalties on foreign companies that do business with Cuba? And what about the precedent created by Secure Flight? How would Canada, or the U.S. for that matter, react if the same measures were imposed by North Korea or less friendly countries? There are also serious concerns related to the huge number of passengers who are intercepted as false positives and have no redress mechanism other than being told to change their names. ICLMG has received testimonies from several Canadians who have been intercepted as false positives on the U.S. list in Canadian airports and have been told by Homeland Security that the Secure Flight redress mechanism could not apply to them because the incident did not occur on U.S. territory. Finally, the published regulations are extremely worrisome, both for what they state as well as for what they fail to address. There is nothing outlining the applicable standards or how decisions will be made to issue these new travel credentials, nor are there any mechanism for travelers to find out why they are denied permission to fly. And none of these decisions are subject to any due process or any judicial review. As you can see, Secure Flight Program will have, or already has, very harmful impact on Canadian travelers and visitors to Canada. We call on you today to strongly and quickly oppose these measures. Canadians expect their governments to protect the sovereignty of their country and uphold their rights. Thank you.
Thank you. Mr. Kenya for 7 minutes.
What I'd like to discuss is the creation or the analysis of the current system in light of what the best overall system is based on empirical evidence in terms of what actually works. So in terms of the current system, we have a system now that in essence is secretive because persons are placed on the list. They're not told that they're placed on the list. They'll find out they're on the list if they're barred when they go to the airport. And then if they happen to be barred, then they have a reverse onus to prove their own innocence. And then they're forced to go to court if they don't get the appropriate decision. And the gentleman that was here earlier seemed to think that there was independent oversight because eventually they'll go to the minister. So my question is, obviously that's not logical. Would it not be better to first have a system that persons were told if they were on it, because at least then they would have an opportunity to defend themselves? Second, there would not be a reverse onus that they had to prove their innocence, but in fact it would be the reverse under our laws. And next, if they did not get a result that they were happy with, if they thought it was unfair, they would be able to go to an independent person, arm's length from the government, call it what you wish, an ombudsman, etc., so that they could get a remedy without having to spend thousands of dollars going to court. So I'd like you to comment on that, please.
I can make a couple of preliminary comments on that. One is, it actually seems, as I've indicated in my comments, that what's really at issue here is trying to ram the Passenger Protect program into these provisions that were never actually envisioned to encompass the program, which is why we don't actually give notice to people. People can get notice of the Passenger Protect program. It's as easy, and this is always what happens with security measures, where you say, you know, it would be top secret how we'd go about doing this. If I were on the Passenger Protect program, I wouldn't be able to get my boarding pass electronically. That would be my heads up. So if we're actually concerned about giving people too much notice, we already have a provision for finding out whether you're on the list de facto. Or, you know, likely. So, yeah, absolutely, as you're suggesting, the kinds of procedural protections that would be in place that you've outlined would go hugely towards making this system fair. But another important thing, though, is that we actually hone onto this criteria of what constitutes an immediate threat. Right now, we have the notion that some people are too dangerous to fly, but apparently not too dangerous to arrest even on conspiracy charges. We do have a criminal code that allows us to actually arrest people for planning. And the concern about the efficacy of this program is very much what happens in the U.S. with the no-fly list, where they don't put anybody who's really bad on the list because they don't want to give them a heads up. Ergo, what's the list for? Nothing.
And I'd like to know what evidence there is that this system actually works. What evidence or studies are there to show that having this form of system actually protects air passengers in an effective manner in comparison to potentially some other system such as screening the quote-unquote good passengers so that more efforts can be put on the passengers who may be at risk or unknown?
Go ahead.
We don't have statistics in Canada, but in the U.S., on the U.S. list, Homeland Security published, or the FBI, I'm not sure which of the two, I'd have to go back to my files. About 2% of people on the list, and the list in the U.S. is huge. We're talking tens of thousands of people. Only 2% have been intercepted. Not a single one of those persons was intercepted for being a terrorist threat or threat to aviation. They were criminals with outstanding warrants. So the U.S. list has been used for giving the police more powers to get after regular criminals.
But as to aviation security, there's not. We've asked several times, which is why you would hear the language that the representative from Transport Canada was using about this being part of a multi-layered, holistic kind of program, because the actual evidence for this program is virtually non-existent. There is no, the Privacy Commissioner's Office has asked for it, evidence of the efficacy of such a program. It does not exist that we're aware of.
Would you agree with me that at a minimum, if they're maintaining the current system, there should be a new mechanism added whereby persons would have the ability to appeal to an independent person who would make a determination rather than having to go to court or rely upon the minister?
We believe the system is deeply flawed, and improvements are welcome, absolutely.
And that improvement you would support?
I would have to vet that by our entire folks, but it is an improvement, absolutely.
Okay. In terms of the, Madame Bernier, you indicated, I think I heard you say that all the recommendations that were in your report were implemented.
Or are being implemented.
Fine.
Both.
So my question is, the false positives, because that's in your report in terms of noting false positives, how has that been fixed?
Well, we have issued our report just a few months ago. So what we have done so far is work with Transport Canada to see how they will fix it. What we intend to do is do a follow-up to make sure that they fix it. But we're giving them time to actually do that. What we intend to do is check up with them again to see that indeed every recommendation have been accepted and therefore is implemented.
So you're not, I take from that at present you're not aware that that has been fixed?
I am not personally aware of how they have fixed it. We have received the assurance that they were fixing it.
Okay. So paragraph 84 in your conclusions, you have 4 different conclusions here in terms of you say some important privacy vulnerabilities that warrant Transport Canada's management attention, and you list 4 here. Mm-hmm. These are very significant, serious. Mm-hmm. Mm-hmm. So the same question will apply for each one of these, since you indicated they're in the process or that they had been fixed.
Mr. Kenya, you have 30 seconds.
Thank you. Whether you can finish now or maybe you can advise the committee through correspondence, I would like to know how these have actually been solved.
Well, absolutely. We will be happy to get back to you as to exactly how they have been solved. Yes, for sure.
Thank you.
Madame Morani for 7 minutes.
Oui, merci, Monsieur.
Thank you, Chairman. I'd like to thank you for coming. Madame Bernier, Mr. Tassé. Excuse me. I'd like to thank all of you for coming. I have a few questions for Ms. Bernier. In your report, I may be mistaken, but I didn't see any assessment of the criteria relating to recommendations. When the CSIS or the RCMP makes a recommendation, what type of criteria would they use for having a person's name? This is not something that is under our responsibility. This audit is aimed at protecting the personal information that has been collected. We have not attempted to deal with the efficiency of the program, and we quite agree with the presentation of my colleagues. The efficiency has not been demonstrated so far, and that we expect that it will be done. We expect that an assessment will be made, and it is not our responsibility then to determine what criteria are applied. Was this not part of the of your mandate, or is this a responsibility that may be given to you? As I said from the very beginning, we dealt solely with the issue of the protection of privacy in these four criteria that include efficiency. In our view, then, the program must continue to be examined from this point of view, and over the years, it must be evaluated and determined whether or not it is appropriate. And if it is not appropriate, then it would be considered a violation of privacy that is not acceptable. Mr. Tassé talked about the American Secure Flight Program. I also discussed this matter with Mr. Tassé, and he told me that the Department of Public Security would be apparently is implementing this secure flight program. What is your view on this? From what I gather, the air carriers will be sending all passenger data to Homeland Security in the U.S. The American Homeland Security then, and they are the ones that will be deciding who will be able to board planes or not. Is that true? I haven't yet received the proposals relating to Canadian measures aimed at responding to secure flight, but I do have a commitment from Transport Canada as well as Public Safety. They say that they will be giving us information for review, and at that point we will be able to conduct an analysis. But I think that it is important for us to note for discussion purposes that the national sovereignty does extend to airspace as well, and that must be looked at from this point of view. Yes, I think that this is a good point. I was going to talk about Canadian sovereignty. It's rather strange, of course, that I'd be talking about sovereignty as a sovereigntist myself, but I believe that each state should be sovereign. And I think that with this American list and all this idea of secure flight, the Canadians end up not being sovereign in their own territory. They're not able to travel where they want to because the American list is being used by air carriers, particularly even in domestic flights, or some flights that may perhaps fly over American territory for a few minutes. This is unacceptable, it seems to me, for a state. In the case of domestic flights that only fly over for a very short time, I gather that they will be exempted. What is being considered at the present time, and in the near future in any case, is flights that fly over American territory for a much longer time, that is for foreign destinations. And we will be analyzing this issue to examine it from the point of view of privacy in cooperation with Public Security and Transport Canada. I've been told that there are domestic flights that are diverted at the present time because a person may be flying over the U.S. to go to another Canadian province, and these flights are asked to change their route. Mr. Tassé perhaps might give us some examples of this. Yes, I talked about Abdullah Al-Maki, who was refused the right to board a flight from Toronto to Windsor, and Air Canada told him that it was because of the American list. There was an overfly over Detroit, and he was unable to make a speech. The Canadian National Annual Assembly of the Canadian Refugee Assembly. There's also Mr. Chakwe, who was traveling in eastern Canada. He had his GPS device on him. He was able to get as far as Halifax or St. John's, but on the way back, the airplane was diverted and had to land in St. John or Halifax with two agents or officers from the Canadian Border Service Agency, and he was told that this was because of the American list, rather. It would appear to be secure flight. They received information about the passenger list, and the flight had to go back in spite of the fact that Canadian Border Services authorized this and accompanied Mr. Chakwi. It was before the federal court decided to drop the case. These are examples then that demonstrate that Canadian sovereignty is certainly being compromised because of this American list. My other question relates to minors. I've heard of a number of minors who were not refused boarding but had to be checked. And when I put this question to the representative of the department, he told me that normally this cannot happen. There's young Alistair, for example, who was unable to travel because his parents were afraid of bringing him along. His parents were afraid of letting him take part in an exchange with other countries. There are people whose names appear to be on this list. We were told by the representative of Air Canada that there are no names of minors on the Canadian list. I don't have access to the list myself.
I'm going to ask my questions from the chair, if I might. I have to say I'm disturbed. I'm very disturbed by this U.S. secure flight program, and I'm not entirely sure what the answers are. But what I hear the witnesses saying is that we don't really have any clear basis for even having such a program. There's been no evidence that has really demonstrated that Canadians need to provide this information, that there's any valid security concern that will come from it. We risk a complete abdication of our sovereignty to a foreign government who will determine where Canadians travel pretty much anywhere. And Canadians have no real redress to challenge this. There's no democratic accountability of the U.S. regulatory authorities to Canadians. There's no way for Canadians to challenge the decisions. We have no idea in any way what criteria would be applied by the U.S. authorities to deny a Canadian an opportunity to travel to Mexico or South America or Europe. But I do think that my friend Mr. McKenzie has made one, I think, valid point, which is this is U.S. airspace and they control it. And even though that disturbs me, I'm wondering how we get around that. If the U.S. demands that we provide this information to them as a condition of flying through their airspace, do you have any suggestions for us as to how the Canadian government ought to proceed in the face of such a demand?
This is the political and diplomatic dilemma. Yes, indeed, we have sovereignty over our airspace, but every other country does as well. So I think the point here, and as little as it suits me to discuss with parliamentarians what parliamentarians should do relative to diplomatic relations, surely this is an issue the world over. What we've seen in the kind of security hysteria since 9/11 is none of these things getting smaller. They only get bigger. The rebalancing around security and liberty only appears to be happening in one direction. And it seems to us time that we reached out to our allies the world over who are also facing these kind of dire sovereignty issues to formulate some alliances and to look for some international solutions to these dilemmas instead of letting them be driven by, as we sometimes euphemistically put, the international forum, but we actually know where that is coming from. So that's my immediate suggestion. The other thing is, of course, we need to let Canadians know it's happening. There is so little awareness around these kinds of issues, and if we're going to lobby this country to try to maintain a view of what sovereignty means in terms of these issues, then first we have to have some awareness.
So I take it you would like to see the Canadian government take a more robust position with the American administration in order to have this this program scrapped, I suppose. Would that be your advice?
Yes, certainly that is ideal. And what I'm suggesting is that we would be on a good footing, I think, with countries the world over who are facing these same dilemmas relative to the mobility rights of their citizens.
Do you happen to know if the situation operates in reverse? Is Canada requiring American Airlines to provide information about American citizens to Canadian Airlines for any flights originating in the United States that may fly over or into Canadian airspace?
I have never heard any such suggestion that we have, or how it might be vetted if we were to do so.
In preparing for this session, I pulled some articles, and there was a very good article by Becky Akers from March 17, 2010 in the Ottawa Citizen, and she points out in this article that at the U.S. government's behest, U.S. airlines have refused boarding to children, to Cub Scouts, Cat Stevens, the singer, Senator Ted Kennedy, and Representative John Lewis, who's a Democrat from Georgia. These are the types of people that have been grounded as a result of Homeland Security and the U.S. Transportation Security Administration instructions. Do you have any concerns that such a list or the furnishing of this information may be used for political reasons in addition to security?
We absolutely have those concerns, and they're shared by our colleagues at the American Civil Liberties Union. Absolutely. The concern about political profiling along with racial and religious profiling is real. The other thing I'll say is the people that you described in that list very much echo the people that complain to us about Air Canada's domestic use of the U.S. List, which included librarians, pastors, and retired persons. So yes, we are absolutely convinced that these are not legitimate security threats that we're dealing with, and when they're not false positives, we have recourse to these other kinds of profiling that we're concerned about.
Madame Bernier, you heard the testimony, I believe, earlier when I was asking departmental officials about the original concerns of the Privacy Commissioner from June 2007. It was quite a litany of very serious concerns about the Canadian no-fly list in the program. And you heard one of the responses was that in 2009, the Privacy Commissioner, at least according to the officials, cleared the program. And I may not be doing justice to the evidence that I heard, but that was my understanding. Can you tell me, is that the current position of the Privacy Commissioner's office, that the Canadian no-fly list in this program is fine as far as you're concerned?
No, because we have never analyzed it in its entirety. We still have outstanding issues. The audit, and in fact one of the first paragraphs of the audit, specifies its scope, and it's a limited scope. It is to ensure whether the personal information was properly, securely held. However, as I've mentioned before, we consider that the effectiveness of the program is still an outstanding issue, that it needs to be addressed, that the authorities are accountable to justify it, and that if its efficiency is never demonstrated, well then the privacy invasion it entails needs to be put in question.
Thank you. Mr. Rathgeber for 7 minutes.
Thank you, Mr. Vice Chair, and thank you to all the witnesses for your appearance and for your evidence here this afternoon. Ms. Vaughan, you indicated in the last round of questioning that you believe that there's very little awareness among Canadians as to these deficiencies in this current system as you described them. Why do you believe that is? Why do you believe there is so little awareness among Canadians? Tens of thousands of Canadians fly every day. Why so little awareness?
I'm referring to the fact that the U.S. no-fly list is going to be de facto imposed on Canadians for a raft of reasons, and is in fact imposed now for various means. I suggest that the confusion that we were seeing in this committee about which list is what and who is who and what's the Canadian no-fly list, and when these people are stopped and we read it about in the newspaper, what does that mean? Is it Canada, or is it the U.S., or is it Liberia, or where is it from? There is such a Byzantine complex of systems right now. I do not believe, and every radio call-in show that I've been on relation to this subject will convince me that Canadians do not know what is going on.
Well, do you really believe it's a lack of awareness, or do you believe that it's a lack of concern? And what I mean by that is that Canadians don't share your concern in that I believe, and I'm going to suggest to you, that the vast majority of Canadians, when forced to form a balance between national security and individual security of airline traffic and their privacy rights, they will err on the side of caution and promote their security interest over their privacy rights.
I would suggest that there's been a shift away from that notion, which has been demonstrated through various studies after 2001. But when you simply put it at privacy, you're right. But of course, it's so much more than that. We've been discussing, and I harbor on this notion, or I keep hammering on this notion, it's Section 7, security of the person, being stranded in a foreign country and not being able to get home, not being able to fly within your own country. We are not just talking, and believe me, I'm a privacy advocate, that privacy is minimized here. We're not just talking about privacy. We're talking about the most imperative security of the person you can imagine.
Well, but certainly security of the person is also imperiled if one is on an airplane where another individual has gone onto that airplane and is carrying explosives. That too imperils the security of the person. You'll agree with that?
Absolutely. No one is suggesting that appropriate, proportionate, efficacious security programs should not be employed on airplanes. There is now not one iota of evidence that no-fly lists are any of those things.
Okay, you talked about Canada's alleged threatened sovereignty, and I'm paraphrasing you a little bit, the legal vacuum that you believe is created by an inability to connect the dots between the legislation and the regulations. Am I more or less paraphrasing what you said?
Yes, that's correct.
Okay. You're a lawyer, as am I.
Yes.
Are you familiar with the Chicago Convention of 1944?
No, what is it?
It is a treaty that Canada and the U.S. are a signatory to, and I'm not an expert in international law, but my perfunctory reading of the Chicago Convention of 1944 is that 52 states plus Canada signed a treaty that's still in force today that states that each country maintains sovereignty over its individual airspace, but determines who can enter its airspace. Now, you certainly, I know we only have a couple minutes left, and we're not going to be able to get into a full international law debate, but you'll certainly agree with me that the ability to sign treaties, binding treaties, is an aspect of the sovereignty of a nation.
Oh, absolutely. No one is disputing that the issue here is not that. And as I've said, Canada has sovereignty over its airspace, as does the U.S. What is being asked for is a complete reverse of what is the standard norm. And as I have said, none of these things ever rebalance in the other direction. We have only seen this go in the direction of increased securitization and militarization. So insofar as we have never seen this enforced in this manner, we should be concerned and we should use our sovereignty to suggest our displeasure.
Okay. The last high-profile incident occurred just before New Year's, where an individual boarded an airplane in the Netherlands and flew over international airspace, probably over the airspace of either France or England, and landed in Detroit City, thankfully without incident. And you all know the incident that I'm talking about. So my question is to Mr. Tassé from the International Civil Liberties Monitoring Group. You're an international organization. You know that this is an international problem. It's not just Canadians that are forced to balance privacy rights versus national security and security of individuals on airlines. Can you tell me, is there a model, is there some other international model or some other country that is doing this better than Canada, or are all the sovereign states dealing with an imperfect solution to a very, very serious problem?
In other countries, first of all, the UK, I believe, such measures, such as no-fly lists, have been legislated contrary to Canada, where it was put in place through the back door. We're not an international organization. We're a Canadian-based organization.
I'm sorry.
Yeah. So our concern is that any measures we know that we need measures for security, but any measures for more security have to respect due process, the principles of fundamental justice. A person have the right to know the evidence against them, They have the right to have this evidence in order to defend themselves. There's no such mechanisms in Passenger Protect, nor even less in Secure Flight. So if Canada plans to develop a new program to mirror the Secure Flight program to deal with this issue of sovereignty, we have to make sure that it is legislated, that is debated in Parliament, and we hear the opinions of Canadians and Canadians' representatives in this House, which has not been the case with Passenger Protect.
Okay, so you're a Canadian organization, but you monitor international civil liberties.
Yes, we do.
So is there a country that has it right, based on your monitoring?
I'm saying to the extent that it's legislated and meets the principles of fundamental justice, that would be acceptable.
What country can I look at?
Well, actually, there's probably no models. Even the U.S. Secure Flight program, even the domestic, it was legislated in Congress, but in my opinion, does not meet the requirements of fundamental justice.
Right. Thank you.
Thank you, and thank you for ending right on the 7-minute mark, Mr. Rathgeber. That was
I'm nothing
well
but
planned.
efficient.
On behalf of all the members of the committee, I'd like to express our appreciation to all the witnesses for your very helpful testimony. Thank you again.
Mr. Davis, I think it would be important that the work we've done today, when we met these people and the people from the RCMP and Transport Canada and Public Security, I think it would be essential that we table a report in the House, as we do for the prison farms. I think it is essential because they are real breaches to fundamental rights. I think it's essential to table a report on this subject.
Oui, oui, tout à fait. Mais peut-être convivialement, sinon j'apporterai ça comme une motion.
We can perhaps decide among ourselves, or otherwise I'll put it as a motion.
Might I consider that to be a notice of motion? And then we would be prepared to consider that at
oui,
the
tout à
next
fait.
appropriate
Une
meeting?
motion, oui. Tout à fait.
Okay. The chair will accept it as notice of motion. Mr. McColman?
A note on the notice of the meeting that this was a briefing, and this was again predetermined in our scheduling process as we came back into session, and certainly this briefing today was very significant, but I don't think it would do us, we'd be doing anyone any favors by making a report based on the little amount of time we have had to consider this and to listen to other people who would like to weigh in on it. Like just to take what we have, the valuable but small amount of information, and to write a report, to me is not doing anybody any justice.
More witnesses.
This was a briefing, not a study.
Mr. Kanya?
Just briefly, that's argument for the motion. So if the notice of motion has been accepted for the next day, then I think we would discuss it fully then, wouldn't we?
Procedurally, if that's the right thing to do, I'm okay with that, but I'm not in agreement that we should be writing a report based on the briefing we've had today.
I think I'm going to agree with Mr. Kanya that it's a notice of motion. Mr. McColman, that may be a valid point of debate that may cause the committee to vote against the motion, but I don't think that goes to the validity of whether the motion can be made or not. So I'm going to rule that the motion is in order and encourage the members to bring those points to debate when it's appropriately moved.
Thank you.
Seeing no further business before the committee, I declare the meeting adjourned.